So my name is Jennifer Wood. I am from the Rhode Island Center for Justice, and one of the things we do at the center is represent a lot of individuals who may be facing eviction or homelessness in housing court, in the district court where most evictions are filed. And so we're here to talk about another piece of legislation that addresses another form of housing discrimination, not source of income, which of course we absolutely champion that bill and think it's critically necessary. But many low-income tenants are also discriminated against if they've ever appeared in housing court due to an eviction having been filed. I'd like you to imagine for a moment that you're working hard, trying to find a safe and affordable home for your family. You identify a rental that you can afford, and you move into that rental after coming to terms with the landlord about what you're going to pay for the rental. You have some concerns that the property may not be entirely up to code or safe, but you're willing to take a chance because you only have a certain amount of rent that you can afford, and you have to find a roof to put over the head of your family. After you move into your apartment, you realize that the situation is much worse than you thought, and you may realize that it is entirely unsafe, unhealthy. You may find that the building itself is structurally unsound, that you have no heat, that you have no appliances, that there may be other utility problems. And so you do what you think you can do based on consulting with people at the Rhode Island Center for Justice or other advocates, and you rely upon sections of the existing law in Rhode Island. You try and repair your apartment and make a deduction in your monthly rent. You contact code enforcement. These are the actions in our existing law that a tenant who is facing an unsafe and unhealthy condition in their apartment is encouraged to pursue. But unfortunately, even if you pursue those avenues, which existing law protect your right to do so, you may find that you get served with an eviction nonetheless, because you may be served with a retaliatory eviction for having exerted your rights and actually tried to enforce the law as it exists on the books today. Unfortunately, most landlords who are doing a background check on a tenant who wants to rent an apartment do not sort tenants by those who have been to court and won their case because they did nothing wrong. They used the existing protections in the law, and they won a case when an eviction and potentially a retaliatory eviction was filed against them. There's no way that people sort and sift. Once your name is on the court's portal as having been served with an eviction, you may be discriminated against, and you may have no awareness that that's why you're not being rented to. So there's legislation that has been introduced again this year, which we're very excited about, which would simply seal the record if a low-income tenant goes to court and wins their case. So in other words, a judge has determined that that individual did nothing wrong and that they were legally in the right, then that would not be something that would appear on the court's portal and would not create a basis for that tenant to be discriminated against by future landlords. There are already many other legal means through which landlords can determine the stability of a potential tenant. Those are all protected under consumer protection laws in terms of background checks, credit checks, et cetera. And in all of those avenues, the individual whose record is being reviewed has the opportunity to review the information being used and to correct that information if it is false. Unfortunately, that avenue is not present as our system is currently structured in Rhode Island, and so the mere appearance of your name on the court's portal may put you on a blacklist as a future tenant. We think that's fundamentally unfair and wrong, and it's a simple correction that can be made to the statute. So we're very grateful for the support of the coalition and think that this is a simple correction that can be made to limit the kinds of discrimination that low-income tenants are being subjected to today. Malchus is, from our partners at DARE, is going to give you some further information about this piece of legislation, talking about the lived experience of the tenants that we sometimes represent in partnership with DARE.